name is Paul White. I am a Central Arkansas attorney who focuses my practice in the areas of estate planning and probate. I've been practicing in these areas about 25 years now, and I want to welcome you to the inaugural edition of 3 Minutes No Filters. It's just an opportunity for me to share some information with you about estate planning and about probate in a very unscripted and, as you'll probably tell, an unedited way. One of the questions that I get a lot is about wills and about probate. People will come in and say, hey, I've got a will. That means that my estate won't go through probate, right? Actually, the will is what takes your estate through the probate process. It's what tells the judge how your property is going to be distributed, who's going to be your executor, in other words, who's going to be the person that administers your estate when you're gone, and then how your debts are going to be paid. Now, if you don't have a will, then absolutely things will go through probate when you pass away. And the only difference is that if you have a will, you get to choose where your property goes. If you die without a will, or if you die without a valid will, then the state has a particular way that that property is going to be distributed, and it may or may not be the way that you want. So a will can be a very important document, but we just have to realize what its limitations are. For people that are married, you may own much of your property jointly with your spouse. You own your house with your spouse. You own bank accounts or investment accounts or just personal property that has both your names on it. Generally, when you pass away, if there is a joint owner on that property, or if there's been a beneficiary designated for that account, then it's going to pass to that other person or to that beneficiary without going through the probate process. Now, there are some exceptions to that, but generally that's the way things work. And so for many married couples, at the first death, there's not a big issue with respect to probate. Nothing has to be probated. The problem can come in when the second spouse dies, or if it's a single person, when they pass away. If there's no joint owner that has what are called survivorship rights on the property, or if there's no living beneficiary designated, then that property can go back through the probate process. And that's why it's important that you make sure that if you have life insurance or IRAs or accounts that have a transfer on death or a pay on death designation, you want to make sure that your designation is done the way that you want it, and that whoever's named on there is still living. Because again, if there's property that when you pass away, if it has no one else's name on it, if it has no beneficiary designated, even if you have a will, it's going to go through the probate process. Now, my 3 minutes are about up. That's today's answer. I can cover that question a little bit more in future editions of 3 Minutes No Filter. If you've got a question, please send that question to me, again, through this Facebook page, or through my personal Facebook page with a private message, or by email at office@pauldwhitepa.com. Thanks for listening.